Today, I'm going to be speaking with Jamal Greene, who teaches constitutional law at Columbia University and also is author of How Rights Went Wrong, Why Our Obsession with Rights is Tearing America Apart. It's so great to have you on. I appreciate it.
Good to be here. Thanks.
So maybe just to frame our conversation, one of the things I've talked about over the last few years is that a lot of these movements that claim to be or are ostensibly about rights and about staking a claim to a right, exercising a certain right, they seem to do this in the absence of an understanding that with rights come responsibilities, and that the claiming of rights in a vacuum seems to be untenable and in some cases an impossibility sort of in modern society. I'd love to kind of first hear your thoughts a little bit about that and the idea of, are rights something that we should be exploring in a vacuum absent any cultural, societal reality? Or is that context absolutely crucial to thinking about rights?
Well, I certainly think that rights are embedded within a society, and we actually have a very long tradition in the United States of thinking about rights and their limits as something that is a collective exercise. That's actually how the framers thought about rights. But we've gone away from that vision and gotten to a place where, and I think this is where your political movements come in, we tend to use rights as political leverage because we tend to think about them in almost absolute terms, as you say, in a vacuum, kind of disconnected from all else, that once you claim a right, then you get to win, right? So the whole game becomes, can I claim a right? Can I get relevant decision makers, sometimes courts, to say that I have a right? And that's what's going to win me my political battle. And I think we need to get back to thinking about rights in political terms, which is to say, in terms of being part of a society.
What is a framework where we can think about situations where rights seemingly conflict, or when we're talking about one's freedom or right to do something versus someone else's freedom or right to be free of that something? What's the framework that we should be applying to those conflicts?
Well, one of the things I emphasized in the book is that rights inherently conflict. They always conflict. And you can, if you think about your right to form a society and to pass laws, right? The government is designed to protect rights. And there's also, of course, another side where there's individuals who are claiming particular rights against what government does. So there's constantly conflict, and you've got to have a strategy for managing that conflict. In the US, our legal system has developed to a place where the way we manage it is to kind of pretend it doesn't exist, pretend the conflict isn't there, and that one side is right and the other side is wrong. So you got to pick who has the right in any particular case. Whereas in many other countries, in fact, most other countries, the way in which the legal system tends to respond is through, I'll use a legalistic term called proportionality, but what it really means is that you kind of background the question of who has the right. You just assume that rights exist on both sides of a lot of legal questions, and you focus much more heavily on what is the government doing, what kind of problem is it trying to respond to, what kind of evidence is it relying on? What kind of alternatives are available to it? Is it acting totally disproportionately, or is it acting basically reasonably? Those are the kinds of questions that we typically ask when we're asking about, is this just? Is this fair? And those questions are totally consistent with the notion that there are rights involved, because you've got to, what I say in the book is mediate between different claims of rights on multiple sides of a conflict and get at really factual questions of, well, what's actually going on here? We don't need to get into kind of a legalistic questions of what does the First Amendment mean or what does the Constitution say? Those questions don't get us very far in answering questions about rights conflicts. We've got to get into the factual details.
So, I mean, to take a case maybe many in my audience will be familiar with, this infamous gay wedding cake case from the state of Colorado. One interpretation of that would be that it's a question of the right of a business owner to make decisions about how they want to operate their business, and the right of the couple wanting the cake not to be discriminated against on the basis of sexual orientation. It could be framed as a right versus a right. All sorts of different participants have reframed it where there's other ways to think about it. one could say, well, it's a judge or jury choosing as to whose rights reign supreme, but is it not that simple?
I think it's not that simple, and it's a fascinating case because I think it really does kind of burrow down on this problem, where I actually think there's even more than two sets of rights involved. So there's the rights of a baker who wants to decide which weddings he bakes cakes for,
Right.
and he's claiming a religious right and also a free speech right because his cakes are really artistic. So
Right.
he thinks that it's a way of speaking. There's the right of the couple to not be discriminated against, as you say, David. And then there's the right of the people of Colorado passed a law that says don't discriminate on the basis of sexual orientation. So they've got rights too, at least the way I frame it. So there's rights on all sides. And you could think of it in the most kind of binary terms as a judge or jury's got to pick, whose rights count. But there actually are lots of overlap in how each of the sides in that case understood the rights of the other side. So the couple actually believed that a baker can choose whether to bake a cake for someone he ideologically disagrees with. He can decide not to bake a cake. And the couple agreed with that. The baker agreed that he actually can't discriminate on the basis of sexual orientation in baking his cakes. He didn't claim a First Amendment right to avoid discrimination. What the disagreement was a much more narrow disagreement about whether refusing to bake a cake for a same-sex wedding counted as discrimination on the basis of sexual orientation. Because the baker said, I don't care who my customers are, I just don't want to participate in this wedding. And so that's an ideological dispute, according to him. He's not actually discriminating against any people. And the couple said, well, no, if this had been an opposite sex wedding, you would have baked the cake. And so that is discrimination. But that's actually a pretty narrow conflict. And what I'm trying to suggest in the book is that judges really need to focus on the narrow part of the conflict rather than trying to decide, do we care more about religious freedom or do we care more about equality for same-sex couples? Those are values conflicts that we're not going to resolve in a court case and shouldn't try to resolve. But we can actually get much closer together if we focus on individual details and facts.
I guess that's the tricky thing where it's very common that you will have a case that starts with what appears to be a decision or a conflict between some broader values about how society or an economy or a culture should operate. And by the time it gets to either the initial court decision or even on an appeal, some subsequent court's decision, it ends up being something very, very narrow. And I think to some degree, that is a source of frustration for many people who would like to have these broader issues resolved sort of like once and for all. And it doesn't happen because the courts end up very narrowly making a decision, as you point out. How should the broader questions be dealt with? Because when they're dealt with so-called democratically, either by a ballot initiative or by the legislatures that we elect, often it's still not permanent in that then it's undone at the next opportunity. I mean, like, how should a society deal with the broader question?
Well, the broader questions of values conflicts, I think the first thing I'll say is they shouldn't be resolved by courts.
Okay.
And this is rights conflicts are ultimately political conflicts. They're conflicts between people who have fundamental disagreements with one another. And it's okay to have fundamental disagreements with one another. That's what makes us human. And in some ways, the core of the book is to say, look, the reason we disagree about rights is not because one of us is right and the other is wrong, not because some of us are angels and others devils, because we're different people. We have different values, different commitments. And when you overlay a legal system onto that kind of disagreement, the legal system has to figure out how do you construct rules that enable people to live together and to stay invested within the constitutional system. So I actually celebrate uncertainty, at least to a degree. I celebrate not resolving rights conflicts for all time because that means that the Constitution doesn't protect or doesn't care about one or the other side of really important values conflicts. I don't think that's the way a legal system should operate. I think you try to mediate those conflicts through politics. And when I say politics, I don't always mean legislative politics or ballot initiatives. I mean other kinds of institutions. Journalists are engaged in acts of politics. When we have social media conversation, that's politics. schools are engaged in forms of politics. Politics is constructing a political culture, a culture of understanding what the core of our disagreements might be, understanding the perspective of other sides, and trying to work towards a solution. That's what political negotiation looks like, and that again, that doesn't necessarily happen in legislatures, although that's the sort of ultimate that's the ultimate power wielder is the legislature. But before you get to the legislature, there's a whole lot of political conversation that has to happen that gets shut off if we think that the way to resolve our political conflicts is to give them to courts who are going to make kind of legalistic, abstract decisions that don't get us very far to addressing our conflicts.
Last thing I want to ask about, during the run up to the 2020 election, I received a lot of emails from viewers and listeners, particularly in Europe, who said, I'm following this election in the United States, and I'm struck by how much talk there is of people asserting rights. The discussion of my right to free speech, my right to vote, my right to a gun, etc., saying that in their countries, this idea of asserting rights just is not it's not a narrative in elections, and that they found that they were curious about, like, how did this become such a thing in American politics where people are constantly talking about rights and asserting rights? Is there some particular history to that in the United States that we can point to about how this issue of the asserting of rights became such a political discussion that in other countries it simply is not?
So I'll say a couple of things. So one is that in Europe, they do care about rights, but they just don't necessarily think of rights as kind of trumps that kind of overcome everything else. And that's what's really, I think, different about our political culture. And I think that I try to tell this story in the book, and kind of the first third of the book. It doesn't come from the founding, which is what we often tell ourselves. The founders had a much more communitarian view of rights than modern Americans do. It really comes out of the 1960s and the post-civil rights era legacy, and it's a complex story. But what it boils down to is a history with race, and with the particular pathologies, the particular problem of people who are being racially discriminated against in overt ways, being kind of the paradigm of rights in America. Right, the core right is the right against racial discrimination. And that's not something you mediate, right? That's not something where you say, well, let's see what the segregationists think, and then we'll kind of see what the other people think. It doesn't lend itself to mediation, because one side of that dispute is completely bad faith, oppressive, abusive actor. But you can't dissociate all of government with, anytime my right is at stake, that means the government's being abusive or oppressive. That's not most rights. That's not most rights conflicts. And so I think we need a language in which we can talk about ordinary political conflict that doesn't take the form of let's see if this is just like Jim Crow, or let's see if this is just like McCarthyism. We've got to take rights conflicts on their facts and actually think about what the government's trying to accomplish and whether it's something that is considered to be legitimate within our tradition.
Very, very well said. The book, as we've been mentioning, is How Rights Went Wrong, Why Our Obsession with Rights is Tearing America Apart. We've been talking with the author of the book, Professor Jamal Greene. It's so great to have you on. I really appreciate your time.
Great to be here. I enjoyed the conversation. Thanks.